call the meeting to order. We'll start with bill introductions. I believe the Department of, or the Secretary of State's office is here with 3 bill introductions. Welcome to committee, Katie.
Thank you, Mr. Chairman. Good afternoon, Chairman Tarwater, members of the committee. I am Katie Copal, Deputy Assistant Secretary of State for Communications and Policy. I am here to respectfully request introduction of 3 bills. All were introduced in the 2020 session, passed the Senate, but understandably failed to get through the House due to the early adjournment because of the pandemic. The first one, if you please, is RS 0681. That is Senate Bill 253 from the 2020 session. It clarifies the service of process on non-resident drivers and certain business entities. The second one is RS 0213. That is Senate Bill 254 from the 2020 session. It updates and clarifies several statutes regarding publications produced by the Secretary of State's office. It also updates statute on publishing notice for amendments to the Kansas Constitution. And finally, we have RS 0696. That is Senate Bill 424 from the 2020 session, minus the series LLC provisions. It clarifies and updates several statutes involving our Business Services Division. It updates the reinstatement process to make it easier for Kansas businesses and nonprofits to reinstate. And it would also allow for biannual business filings.
Okay, thanks so much. Without objection, we'll go ahead and enter those 3 bills.
Thank you, sir.
The Department of Commerce, do you have a bill introduction?
Thank you, Chairman. David Sofer, Legislative and Policy Director at the Kansas Department of Commerce. We too have 3 bills. One from last session is the Star Bonds bill, which was HB 2529 last year. So the RS is 2021 RS 0003. And then the next one we have is related to Hbip with the ability to transfer those tax credits. That is 2021 RS 0456. And the last one I have is related to an expansion for the Rural Housing Incentive District. So that's 2021 RS 0445.
Thank you, David. Without objection, we'll enter those 3 bills on your behalf. I have a bill introduction. The RS number is 21RS0592. This is the Kansas Promise Act. And I'm going to go ahead and enter that one. Thank you. Any other bill introductions? Online? Seeing none. Okay, we'll close the bill introductions for today. And we're going to open a hearing. We have 2 bills today that we're going to hear, committee, that we actually heard and passed last year, but they didn't quite make it because of the pandemic. They seem relatively easy. We probably should have started everybody off with these 2 bills, but it's just not the way they came to us. So we're going to go ahead and open the hearing on HB 2112. And we'll start with an introduction of what the bill is from Charles Reimer.
Now?
Oh, yes, sir. Thank you.
Awesome. We picked the right microphone setting. So I'm going to share my screen here and discuss 2112. So the committee may recall this is a bill that was from last year. Last year it was House Bill 2454. This bill is substantially similar. Again, this deals with self-storage rental units pertaining to 3 areas of interest for self-storage rental units and their operators and consumers who use them. The first item, you can see I've highlighted there, is a provision that limits the claims of damage for an operator to the maximum value that is permitted, the maximum value that can be stored in the lease space under the terms of the rental agreement. So there is a damage limitation. That's the highlighted language there in subsection B. The second thing the bill does is it provides space and a query in the rental agreement for a renter or occupant, I guess rather, who wants to designate an alternative contact to receive notices that are required under the Self-Storage Act. So you'll see that the failure or refusal of an occupant to designate an alternative contact doesn't affect either the occupant's or the operator's rights. The alternative contact, if one is designated, does not have any rights to access lease space or to the personal property stored in that space, unless the rental agreement expressly provides otherwise. It's just an opportunity for an alternative contact for purposes of notice for the occupant. This is a new provision. This was not in the bill from last year. The third thing that the bill does is it provides for online sales of property in the event that there is a default. You'll see there that advertisement in that instance is to be done in any commercially reasonable manner, in addition to if the operator wants to do it, you know, the way it's been done in the past in the newspaper, they can do that, or alternatively, they can use a commercially reasonable manner to do so. And then there's a provision that if there are less than 3 independent bidders that attend the sale in person or view the sale online at the time and place advertised, then it's deemed that the manner of advertising the sale was not commercially reasonable. In that case, the sale is to be canceled, rescheduled, and re-advertised. So that's a provision there to ensure that the sale of the property that has been abandoned, not for lack of payment or some other reason, is not there. It is actually a good sale that occurs. There's also the provision, further notice to the occupant shall not be required. That was there in last year's bill. The language that I've highlighted here is slightly different from last year, I think, for clarification purposes. And that is what the bill does. The bill is effective, if passed, July 1st, 2021.
Thank you, Charles. I like the way that you're presenting the bills. This has a lot more clarity than the ones last week. It's nice to be able to see it and have it highlighted like that. Thanks for doing that for us. I have one question. This requires a minimum of 3 persons bidding. Currently, if they advertise in the newspaper, if 1 or 2 bidders show up, are they allowed to go forward with the sale, or do they have to redo that ad as well?
Currently, there's no requirement for the number of people who show up. There's just a requirement that that the advertisement be placed in the classified section of the newspaper.
Okay. Any further questions? Any questions for the reviser? Representative Miller, you have a question?
Yes, thank you, Mr. Chairman. Is independent bidder defined?
The independent bidder is not defined in the bill.
And what's to keep the storage operator from just having 3 people present claiming that they're bidders?
I guess it would be the definition as interpreted by a court of independent bidder, which I think there would be some aspect to that term just in the normal understanding of language that there would not be collusion involved in the bidders who showed up for the sale.
Thank you, Mr. Chairman.
Representative Carpenter.
Thank you, Mr. Chairman. So why was the language added for 3 when it's not required in newspapers?
I would respectfully maybe pass that question to the proponent. I would surmise that it provides some assurance that an online sale would be, done reasonably, but I would leave that to the proponent to address that.
Okay. Well, I just can't imagine it being more restrictive or requiring more than we're required right now from a newspaper. So on to my next question. Paragraph D on the first page, a query into the occupants, a second contact. So where did that come from?
I need to find the language here.
You said it wasn't part of last year's bill.
No, what I was referring to was that, right. Yes, the alternative contact is a new provision in this bill. And, as far as why it's in the bill, I would refer to the proponent. But that is a new provision there on the bottom of page 1 that allows for an occupant to designate an alternative contact.
Okay, thank you.
Yeah, Representative, I believe that several sides got together to negotiate this bill, but we'll hear from them here in a minute. Any other questions? Seeing none. Go ahead and start to hear from the proponents.
Mr. Chair.
Dameron.
Mr. Chair, there are questions.
There are questions.
Okay, Representative Ralph, I understand you had a question for the reviser.
Thank you, Mr. Chair. And looking over here, I think there probably are another couple of hands raised over in the participant panel there, but thank you for the time. Chuck, I think I also have a question on the independent bidder attending, because as the previous representative had indicated, without a definition of independent bidder and the reference to them attending, I'm having a difficult time even picturing how someone would establish whether in fact there had or hadn't been collusion about any of this, because even the reference to an independent bidder attending, it doesn't sound like the independent bidder has to bid even to make that effective. So I'm just curious if you've got some additional understanding. I know you just drafted this, but some additional understanding as to how that independent bidder would have any effect on this sale if they just attend and don't, for example, just don't say anything.
I'm sorry, Charles, I muted you because we were getting a lot of background noise and I'm trying to figure out how to unmute you. You're going to have to unmute yourself, sorry.
Okay. Yes, Representative, you are correct. There's only requirement that the independent bidders attend the sale or view the sale online. So I really don't have any other response to your observations, but you are correct in what the language states.
Thank you, Chuck. I appreciate that. Thank you, Mr. Chair.
Representative Williams, I'm sorry that we skipped over you as well.
No problem. Thank you, Mr. Chairman. So on page 2, line 36, when it talks about the commercially reasonable manner, I don't know how many people, maybe in this industry, they do use the classified ads of a newspaper, perhaps that they use it online, I'm guessing. So my question is, commercially reasonable manner, could it be through another means such as social media?
My apologies. Because commercially reasonable manner is not defined in the bill, I think Representative, your view that social media could be used, I think, in this day and age, that could very well be construed as a commercially reasonable manner.
Okay, thank you.
Representative Clayton. Okay, any further questions online? Okay. All right, we're going to move on to Whitney Dameron.
Chairman, members of the committee, appreciate the opportunity to speak before you again this year. As Mr. Reimer stated, this bill is very similar to legislation brought before the committee last year that passed the House chamber 114 to 9. Scheduled for hearings late in the regular session last year in Senate Commerce, and actually the very last week before you reached first adjournment. So we had hearings on the bill. There were some questions raised in committee, which we've attempted to address for this year, but the committee did not have a chance to work it before first adjournment. So I will walk through what we see the bill is doing. I'll respond to the questions that have been raised as well, and then certainly respond to questions. So the first change in the bill that was highlighted by Mr. Reimer has to do with making damage loss limitations in contract enforceable in law. The challenge the industry has had in some jurisdictions is that even though the contract might limit the value of the contents in a self-storage unit to a number, $5,000 for example, some people might put some things of much greater value into that facility, and the potential is there for litigation. Some courts have not held that the contract was binding or valid with that limitation. The concern that the self-storage operator has in limiting the value of items stored in their facility is it's not intended to be a safety deposit box. It's intended to store common household goods and the like. If you put things in there and it is known they are very high value, extensive firearms collections, coins, rare cars, antiquities, and the like, it elevates the likelihood of criminal activity, theft at night, and so forth. So that's the reason for that section. The second issue, that language is found in a majority of states. It's also found in the 4 states surrounding Kansas. So Missouri, Nebraska, Colorado, Oklahoma have that in statute. Third-party notification of potential default and contractual obligations. So in the Senate hearings, the question was raised, or examples were suggested that someone could move away, not receive notice. Someone could go into a care home, and they would not get notice. The next thing they find out is all of their goods have been stolen. We disagree with that presumption. However, we're sensitive to the optics of that concern. So we've incorporated language that said when someone comes in and enters into a contract for a self-storage unit, if they choose, they can designate a third party to be notified in case there's a default into the contract. Could be a friend, could be a relative, anyone they want, could be their attorney, accountant, whomever. But that is new language. It's a new protection that we essentially developed working back with the Self-Storage Association. And most self-storage operators accommodate that already. It's just not in contract, so we thought we would spell it out in our bill this year. Under current law, just as background information, if someone is in default of their contractual obligations, they're notified through first-class mail. That was changed some years ago. They also have the ability to provide electronic contact information, whether it's texting or email, if they have such communications devices. So those kinds of communications are what's going to the person who's renting who is behind in their payments, or if there's other issues relating to their unit. The question was also raised, which I did just want to clarify for the committee last session when they talked about items being sold when someone was unaware that they were in default of their contract. And the example was raised, someone could be deployed in the military out of the country and come home and find out all of their goods or stored goods were sold. That is not allowed under federal law. Anyone who's in armed services, you cannot sell their items under any kind of a circumstance like this. So that is not applicable to this situation. The third issue, allow auctions to be conducted in person or online. That was trending certainly even before COVID came up. Majority of states have that ability. All of the surrounding states to Kansas have that ability. The last session in the bill, since that was a change, going from an in-person auction to allowing either in-person or online, we attempted to put forth some kind of a standard that would demonstrate that it was truly a real auction and that people were participating, and that's where the three independent bidders language starts to come into play in this bill. Typically in an auction, as in any auction, in order to bid, you have to register, and self-storage auction is no different. They want to know who is bidding. If you go to a farm auction or whatever else, if you want to bid, you have to sign up, you have to get your number, and that is the kind of information that would be used to determine whether someone was an independent bidder. Typically, these auctions don't have 2 or 3 people, they have 15 or 20. If you open it up to online, you're going to have probably substantially more, given industry practice. Finally, number 4, public notice, sale of auction. Current law requires, if you're going to have an auction, you have to publish in the official newspaper record in the city or county where the self-storage facility is located of that auction. We have put in their language to allow either publication in the newspaper or in any other commercially reasonable manner. So that is not defined in the bill. That issue was raised in this committee last year as well as in the Senate. What does that mean? We've essentially created a standard that, for lack of a better term, the proof's in the pudding. If you put out notice for an auction and you get less than 4 people, if you get 3 or less that show up to that auction, it wasn't done in a commercially reasonable manner by definition because people didn't attend. We don't think that will be the case, but we have put in the bill essentially creating that being the standard. I'd like to note that the purpose of the notice in the newspaper is not to notify the renter of the self-storage facility. It's to notify the public that there's going to be an auction held, and you, in that advertisement, what you have to put in is the time and the location and the terms of an auction. You do not have to put the name of the person who owns that unit in the advertisement because their notice comes from first-class mail, email, telephone calls, or now a third party that they put into the contract. It does not come from what's placed in the newspaper. You may or may not see names in the newspaper for these kinds of notices. Quite frankly, one of the reasons that a self-storage operator puts names in the paper is it's practice for people who like to go to these auctions to try to determine who owns the unit, what their occupation might be. For example, if they're a mechanic, then they think there might be tools that are going to be auctioned off. But it's not to notify the person who is actually renting the unit. The industry is moving away from these kinds of advertisements in newspapers. If you Google self-storage facility auctions, you'll get any number of hits that come up on your computer. They'll ask you to put in your geography. They'll direct you to websites that track these kinds of things. Self-storage facilities typically post their auction dates online on their websites. They also notify anyone who has to be notified of an auction. So that's how people are finding out about these auctions. Our world is rapidly now shifting to online communication to people, and we think that's appropriate. The newspaper subscriptions, quite frankly, are down. They're expensive. There's paywalls you have to navigate, even if you don't subscribe to a home delivery. And this kind of language has been approved in 17 states. including Colorado and Nebraska. There's 5 states that have reduced publication requirements and 3 states that have no publication requirements whatsoever. So that's a run through of the bill, and be happy to stand for questions and appreciate your consideration. Thank you, Mr. Chairman.
Thank you, Whitney. Are there any questions online? 0. Any questions from committee? Representative Clayton.
Thank you, Mr. Chair, and thank you for being here today. I'm definitely a beneficiary of storage sheds and want them to stay in business and do well, because I don't want a bunch of comic books in my house. So my big question here, though, is this, like, especially to point 4, how detrimental is it to the storage shed industry to have that newspaper requirement? Like, how much would you say it would cost them, like, per year?
Well, every time you have an auction, there's a cost. There's also, and putting legal notices in a newspaper is not inexpensive. They can range anywhere from $200 to $300 or more, based upon information provided to the Senate committee last year. And again, we feel that it's certainly not what is in law to notify the person who has the unit, but it's in law to drive people to come to the auction. It is incumbent upon the self-storage operator to get as many people coming to that auction as possible, because that's how they get their past due bill paid. And anything over and above what is owed to them goes back to the renter, and if they can't be found, it goes to the state under unclaimed property.
Thank you. And just one more question. Do we know, just on average, about how many, like, how often do these auctions take place? You know, once a month? Or, I mean, I would assume that it's, you know, at the discretion of the storage shed facilities, you know, schedule. But, you know, on average, is this like a once a month thing for a lot of these businesses? Once a quarter? Once a week?
It's case by case basis. From experience of someone who I've dealt with here in Topeka, quarterly might be an average timeline.
Thank you. Thank you, Mr. Chair.
Okay, I have a, so my wife goes to these things. She's been starting to watch these auction things online, and she'll attend them. And it's almost like a cult of people. I mean, there's 15 or so people that she sees at all these auctions that she goes to, and it creates quite the competitive atmosphere. I can tell you, sometimes she comes home with things that are very surprising that she'd be interested in, but just basically got involved in the heat of the, you know, she was, the guy might have outbid her on something she wanted, so she bought his item, and we end up with it. But anyway, that kind of thing happens. But I guess the point of this story is that she doesn't look in the newspapers for these things. There are several sites, and she receives emails every morning on where all the auctions are, and so it's pretty organized outside of the newspaper. And I would imagine if you could cut that extra fee out, it would be helpful to the industry.
That is correct. This just provides, quite frankly, a better opportunity to inform the public where these are at and to reduce their business costs.
Any more questions? Any further questions? Cindy, if you could send an email to Representative Highland. He texted me, he can't get into the WebEx. It's a connection issue. Okay, got it. All right, moving on. Are there any other proponents here to testify in this bill? Are there any other online? Seeing none. We'll close the proponent testimony, and we'll get to the opponents. We have an opponent, the Kansas Press Association. Is anyone here representing the Kansas Press Association, or are they online? I was assuming it was a written-only testimony, and That's kind of been an issue in this committee. So committee members, just so you know, a heads up that we will be issuing a supplement to the conferee rules with them to respond with their testimony, whether or not they're an opponent or a proponent, and whether or not they're going to be in person or virtual. And hopefully that will help clear up some of this issue. But you do have some, it's quite a large testimony, and it comes with some slides. But there was there was one opponent, that's the Kansas Press Association. And seeing no other opponent testimony, we'll close the hearing on HB 2112. Committee will open the testimony, or we'll open the hearing on HB 2097, and we'll start with the reviser, Charles Reimer. Thank you.
Thank you, Chairman. And I will share my screen again. House Bill 2097 is also a repeat from last year. Last year was House Bill 2702. This bill pertains to the High Performance Incentive Fund, which is one of the significant programs of the Department of Commerce, one of their major economic development programs. Under current law, there are a number of requirements for a firm to benefit from the tax credit that this program allows. There are wage requirements for the employees. There are investment requirements depending on whether it's an urban or rural situation. And there's also currently a requirement that the company participate in the department's workforce training programs. This bill removes that requirement from the High Performance Incentive Fund tax credit program. There are two references in the Hbip statutes to the Kansas Industrial Training, Kansas Industrial Retraining, the department's workforce training programs. The first one there is just in the first page of the bill in 745133. The second reference is in the tax credit statute that addresses the Hbip program. And the tax credit provisions are in subsection E of this statute. And there you'll see that there is a reference, a requirement that the company have participated in those workforce training programs, and that has been removed as well. The other, you'll see numerous other changes in the bill. Those are not substantive, that's just statutory cleanup. And the bill is effective, if passed, on July 1st, 2021. That is what the bill does.
Thanks, Charles. Any questions for the reviser on this bill? Any online? Okay, seeing none, committee, this bill also has a fiscal note, and I've asked Eddie to speak to that if he could.
Yeah, thank you, Mr. Chair. Can you hear me there in the room?
We can.
All right, great. Yeah, there is a fiscal note, so to speak, with this bill, as it kind of removes one of the hurdles required to claim this credit. Unfortunately, if you review the fiscal note that's been provided by the Division of the Budget, it was just issued today, so I'm not sure if you would all have that in front of you there in the room, but it is available. It's kind of a fiscal note that says impossible to determine. That it's impossible. We don't know how many possible participants are not participating because of this requirement, and accordingly, it's not really possible for the Department of Revenue to quantify what that fiscal impact might be. So there is a fiscal note, but not a lot of information that can be provided for that.
Thank you very much. Any questions? Seeing none? Oh, Representative Johnson.
Thank you, Mr. Chair. I'm curious if anybody has a guess, either on the committee or on staff, of whether this is I would assume this is not a huge change relating to the fiscal note, but I don't know if that assumption is appropriate.
I think you're right, and I think that the Department of Commerce is prepared to speak to that when they come up. So, any other questions? Seeing none, we'll go ahead and start with the proponents of this bill, and David Sofer with Department of Commerce is here.
Good afternoon again, committee. David Sofer, Legislative and Policy Director at the Department of Commerce. We stand in support of 2097. For those of you that were here last year, this is 2702. This passed the House 125-0, passed the Senate 39-0, but unfortunately, we just ran out of time and it didn't end up getting taken care of. But there is broad support for it, and we're hoping for so this time around as well. Before I kind of get into what the bill does exactly, I think a really quick summary of what these programs are, especially for those members that are new and may not be as familiar with each of these programs, might be most helpful. So I'll start with the Kansas Industrial Training and Kansas Industrial Retraining Program. Those have acronyms known as KIT or KER. So Kansas Industrial Training Program is designed to assist firms involved in net new job creation. So if you're a company moving to Kansas, it's any new job here based in Kansas, or if you're already located here in Kansas, you must show that you are creating a net new job that you didn't have previously. So the way this works is we look at the average number of like permanent and full-time and part-time employees over the last 12 months to determine that. But really quickly, I mean, what this does really, so these programs are aimed to help companies deal with the costs when it comes to training new employees, whether it be their machinery, whatever it is they need. So it can help with things like salaries for trainers, materials, training aids, or even minor training equipment. And then Kansas Industrial Retraining is designed to assist companies who are restructuring or retraining their workforce. So you must show that you're restructuring your business operations or retraining your workforce. And I listed the 4 items. So it's incorporation of existing technology, development and incorporation of new technology, diversification of production, or development and implementation of new production. So a company must show that employees to be trained are likely to be displaced because of obsolete or inadequate job skills or knowledge, which is why the training is critical. A company must retrain at least one existing position. The training plan must be concurrent with the project start date. So, when a KIT-KER contract is created, there's a job baseline stated in the contract of how many jobs you're going to train. Or, in KIT's case, it's how many jobs created. There's also a minimum amount of training investment a company must make in order to receive the what we'd call a reimbursement grant. And then, again, you have to provide the receipts, the training roster, and reimbursements are based on the proportion of the company's matching funds as agreed to by the contract. So if they meet all the requirements, they receive the reimbursement grant that was agreed to on the onset. It's important to note that this is one of the major and only training programs or incentives we have in our state. So if a company needs assistance with being able to train employees, this is really the one program that is specifically geared to this. The reason why I mention this is that, since 2010, funding for this program has dropped from $2.8 million to $1.6 million. So as you might imagine, nowadays when training and retraining is so critically important to companies to be able to compete in the work, with other companies outside of our state and be able to keep workforce here, to have less money to be able to do that, it's difficult. And so when you think about it, back then we were able to offer a max of $2,000 per trainee. Now that's well under $1,000. It's actually $600. So, as you'll get to see with why we need to pass this bill, just remembering that critical component that, we have limited dollars to be able to address the training and retraining needs. And why this inefficiency contained with Hbip, related to this program with Hbip, is so critical to change. So putting KIT-KR aside, I want to just briefly cover Hbip. Hbip is one of the most valuable incentives we have. It's not discretionary, so it's based off of statute, and you either qualify based on the requirements by statute or you don't. So you must be a for-profit company, pay above average wages compared to other similar firms in the same geographical area with matching NAICS codes, make a significant investment in eligible employee training currently, or be a manufacturer, and there's other, exceptions to that. But there's 3 critical benefits. At least offered now, it's 2 critical benefits and 1 we would like to change. The first is you get a 10% income tax credit for eligible capital investment. Now, there's 2 different standards. So in most of the state, it's $50,000. In the 5 metro counties in our state, so Sedgwick, Shawnee, Wyandotte, Johnson, and Douglas, it's $1 million. So you would get 10% of that investment. So let's say you make $1 million capital investment commitment in Johnson County, you'd receive $100,000 in tax credits, and then you could use that tax credit against your tax liability. It's not refundable, but you can use it against your tax liability in the remaining 16 years. And then you also receive a sales tax exemption to use in conjunction with the company's eligible capital investment purchases at its qualified facility. So, what does this bill do exactly? So just to quickly sum up what, and Charles covered it nicely, currently the way it works in statute is a company in Hbip must make a 2% commitment for training of its state payroll. So as you might imagine, for some of the bigger companies in our state, even moderate size, 2% commitment each and every year to train your employees is quite a bit. Now, it may not even be necessary. The important piece to remember about Hbip is that this program specifically deals with large capital investment and well above average wages, just generally compared, in the nation. So specifically for that sector. So when you think about it, a company that is paying that kind of wages, and on top of making a major capital investment, they are training their employees as needed. Obviously, you're not going to pay those kind of wages if your employees don't have the skill sets necessary to be able to produce the job. So when you're putting on that type of commitment, it doesn't help the program itself. It doesn't help the company. It makes the program inefficient and not nearly as effective, especially when you compare this program to some of our counterparts across our country. I mean, the goal of the incentive is to be able to convince people to come here. If they're looking at these requirements, it is very difficult to necessarily get them to buy in on this. So when you think, so that's on the 2% side. Now, what does the KIT-KR have to do with all this? So quite a few years back, as you might imagine, folks complained about the 2%. So they wanted to create a loophole for this. So what they said is that instead of doing the 2% state payroll, training requirement each and every year, what you can do is instead you can qualify for KIT-KR. You only have to train one or 2 jobs, and as long as you qualify for that program, you get the training grant reimbursement, you're good for Hbip. The problem with that is, again, so we've got the limited dollars we talked about, but then there's a whole inefficiency. So if you're paying people just to qualify for another incentive, the KIT-KR incentive is losing tremendous value as the only training incentive available, on top of the fact that you're just wasting taxpayer dollars. They're being used in such an inefficient manner. We should be providing KIT-KR to companies that need training. We shouldn't just be passing state dollars just to get them qualified for one incentive so they can qualify for the other. So just to kind of give you some numbers, just so you understand about what kind of problem we're talking about here. So in the last 3 fiscal years, so FY 18 to 20, of the 872 certifications we did for Hbip, 43% of those companies used KIT-KR to qualify. Now, on the flip side, when reviewing KIT-KR grants over those 4 years, we saw over $4 million go out simply to qualify companies for Hbip. That's $1 million a year. So when you start thinking about that kind of dollars that we could be using in a much more efficient manner to gear towards what companies need, especially nowadays, as we look to bounce post-COVID and getting our workforce where it needs to be, it is so critically important that we use every single dollar allocated to us in an effective and efficient manner. What you'll see, and this is going to be presented next week when we present to you our economic development plan, the framework for growth, there's a major gap of highly skilled individuals in our workforce. So this is KIT-KR is one of the critical incentives that can help us to address that by working with companies to be able to train those employees that lack some of that skill set so they can start working and they could get trained at the same time. So just to sum up, this legislation addresses two key issues. KIT-KR will no longer be used as a qualifier in order to be able to qualify for Hbip. This frees up funding to specifically focus on training-based projects through KIT-KR. And then on the other item, the 2% training requirement in Hbip would be eliminated. This is, again, critically important because this is why the whole problem began in the first place. Companies that are paying high wages, that are paying major capital investment, they're doing the training. I'm sure many of them would come to you and tell you this. This is not something that they need an incentive for. Them being able to do this will keep their employees there. That's why they're paying them major wages. And so one of the other things that we're going to get into, one of the bills I introduced today, Hbip as a whole is one of the most valuable incentives because, again, you qualify by statute. It's not, sometimes we get into the debate of, well, we're picking winners and losers, but the beauty of Hbip is that you qualify based on what you're doing for your workers, the type of investment you're making in Kansas. We need to invest a lot of energy and be able to make that program the most competitive, efficient program available. So one of the things that we've seen is those tax credits are very hard to utilize because you can only use them against liability. So one of the things we have talked about, and that's why that bill was introduced today, is we want to be able to make those tax credits transferable. We want to be able to create an incentive program that truly is appealing to our businesses all across our country to come here, to stay here, to grow, to prosper, and see Kansas as their home long term. That's the type of programming we need here in Kansas. These are the types of jobs, wages, actions that will propel our state going forward, and it's a major focus point for the department as we continue to get through some of the challenges we've seen in our economy and be able to kind of see as we get to hopefully the light at the end of the tunnel, how are we going to advance our state in the next 5 to 10 years? How are we going to make our state a true business home and capital in this country? We want to be able to welcome all the opportunities here, be able to keep our kids, our young folks here, see the opportunities here at home. And we do believe that Hbip is one of the critical programs to be able to do that. So with that, we support the passage of 2097. We request the committee report HB 2097 favorable for passage, and I'll be happy to stand for any questions.
Thanks for all the details. Representative Hoffman had a question.
Thank you, Mr. Chairman. David, I just want to clarify, and I'm pretty sure I understand it, but this does not change the qualifications for the KIT or the KR project or incentives in any way. It simply it changes the qualifications only for the Hbip.
Correct. So companies that have only applied for KIT-KR simply to qualify for Hbip would no longer be applying for KIT-KR because they would automatically be applying for Hbip.
Okay. All right. Thank you.
And then actually that reminds me, if I may address Representative Johnson's question initially about the fiscal note. The reason why we anticipate this having a minimal, the reason why we anticipate this having a minimal fiscal note is because companies could easily apply for KIT-KR, train 1 or 2 jobs, and then they would qualify for Hbip. There's no real kind of wall at this point to prevent them from qualifying for Hbip. If anything, the state is, again, using taxpayer dollars in an inefficient manner simply to get them qualified. So any company that currently wants to qualify for Hbip already has a very easy ability to do so. We don't anticipate this dramatically increasing the amount of companies that are participating in HBIP.
Good with that? Okay.
Sorry about that.
So basically, we're just freeing up the training dollars for the other program. And is there a maximum on that currently?
So currently, we do have one on the training program. We get 1.6 million annually for that program. And as of right now, because there's so little dollars that are allocated specifically for KIT-KER projects, we only give out a max of $600 per trainee. The goal is that if we're really only focusing on KIT-KER based projects that are only training projects, hopefully we can make more meaningful, impactful awards for those projects.
Okay, I have a couple of questions for you on the HBIP program. Last year we had some county commissioners come up and testify in their personal capacity because they've dealt with some of these HBIP programs in the past. And they had a concern, and it's the number 2 qualifier, that they have to pay above averages as compared to other similar firms in the same geographical area. It seems that, have we ever audited this program to make sure that that's happening? Because there's a lot of commissioners that think that it's not happening.
Yep. No, again, so what you have to do is the beauty of HBIP is you have to recertify each and every year. So as part of that, you're basically going through an audit process each and every year where our department is reviewing those records, making sure you are paying those wages every single year in order to continue with the program. If you don't end up recertifying, then any unused tax credit can no longer be used. So it is in the company's best interest to recertify, and it is in our best interest to make sure that they are indeed telling us the truth and making sure that those numbers are correct.
Okay, and in some of these other programs that we're putting forth, maybe when the bill you put in today, but the one that I did certainly requires a Kansan that we spend tax dollars on to retrain or to train, that they live and work in the state of Kansas for, I think it's 3 years in the bill that I put forth today. Are they required under the KIT-KER program to stay working and living in Kansas for any period of time after we expend taxpayer dollars to retrain them?
I don't know the answer specifically to that question. Let me double check. I do know they have to be a Kansas resident at the time, but let me make sure on that and I'll get back to you.
That's a concern of mine strictly because currently 62% of our college graduates leave the state and work and live in other states. And so I want to make sure that any further tax dollars that we invest, we do our best to keep those people here in Kansas and productive citizens.
Sure.
Any other questions? Oh, Representative Clayton, I'm sorry.
Thank you, Mr. Chair. Thank you for being here. I just have a question, and I'm a little bit remiss for not bringing this up when we've spoken about this earlier, but where do labor unions come into play in regard to this at all? Do they benefit? Can they?
Sure. I mean, again, so every company that participates, whether it be unionized or not, certainly, it's critical for their workers to be trained. So there is no, if a company certainly has unionized workers and they work it out with the union that they want to be able to train them, certainly they can participate in this program. So there is benefit to all Kansans, unionized, non-unionized, and the like. It's really a program that is tremendously helpful to all workers.
Thank you. Thank you, Mr. Chair.
Sure. To kind of piggyback on that, so if a worker is in an apprentice program with the union per se, is there a way for the company to help train that individual also, or can the union get these credits?
That's I'm not as sure on the technical aspect of that. I will double check and get back to you on that.
Okay, thank you. Any further questions? All right, thanks for the information. Appreciate it.
Thank you.
We've got Manhattan, Emporia, Topeka, Lawrence Chamber. Are you here to testify today or online? Nope, written only. Okay. Kevin Walker, is a proponent, but I believe he's written only as well. Steve, Jack, are you here today? Okay. Committee, it looks like everybody else on this, there are all opponents or all proponents, and most of them are written. You do have those testimonies were all emailed to you earlier today. I don't see any opponents to this bill currently. No opponents, seeing none. We'll go ahead and close the hearing on HB 2097. Well, we're finally going to get out of here early. Representative Miller.
Thank you, Mr. Chairman. Is Representative Ralph still with the committee?
Yes, sir, he is. He was ill for the first week or two, and he's back now.
Is he still online?
Yes.
Representative Ralph?
Yes, Mr. Chair.
Would it be too late to amend the committee rules to require members not to dress inappropriately?
Representative Ralph, what are you wearing?
I appreciate the representative's concern, Mr. Chair.
We'll consider it, sir. Moving on. Committee, tomorrow we have an important meeting. We've heard from the Department of Labor for 6 hours last week, and tomorrow we're going to have several employers and HR individuals come speak to what they're experiencing and how they're doing their best to help the citizens of Kansas that are filed for fraud and all that. It'll be, you know, they came a few times in front of us in the interim committee, and it was eye-opening, some of the things that they're having to do, and they've got a lot of ideas, and they're weighing in on the unemployment fix that we're working on, and so they're a wealth of knowledge. So please come with you know, loaded bear with questions, because it'll be a pretty strong meeting. Also, I want to remind you, on Thursday we plan to work the angel investment bill, and I want to remind individuals that you have to be in this building to make a vote of any kind. You don't have to be in the committee room, you can be online, but you do have to be in the building. So just make sure that all your friends are in the building when they're ready to make their vote. And with that, we'll adjourn. Thank you very much.